donate.
Oh, yeah. That's a terrible motion.
Except great job.
But I'm
Oh, you
sure
saw it.
I saw it, yeah. It was over.
The thing is this is paying them more.
Senate will please come to order. Senate will please come to order. Please join me in a moment of silence in lieu of a devotional this morning. Good morning.
Morning.
Are there any announcements? Seeing none, we have 6 gubernatorial appointments this morning, which we have received from the governor's office and which are now being referred to the committees having jurisdiction. These appointments will appear in today's journal, which you will receive on your desks tomorrow. We have a Senate bill for introduction. Oh, I'm sorry, Rule 31 referral. This is S-139, an act relating to the modernization of public safety communications in Vermont. This bill appearing on the notice calendar and affecting the revenue is under the rule referred to the Committee on Finance. We have S-137, an act relating to energy efficiency modernization, received March 21st. And this bill appearing on the notice calendar and carrying an appropriation or requiring an expenditure is under the rule referred to the Committee on Appropriations. We have House bills for reference, first of which H62, introduced by Representative Houghton of Essex Junction. Please listen to the first reading of the bill.
H62, an act relating to the Interstate Counseling Compact.
Now the bill has been read the first time and is referred to the Committee on Health and Welfare. We have H77, introduced by Representative Odie of Burlington. Please listen to the first reading of the bill.
H77, an act relating to Vermont's adoption of the Physical Therapy Licensure Compact.
Now the bill has been read the first time and is referred to the Committee on Health and Welfare. H86, introduced by Representative McCarthy of St. Albans City. Please listen to the first reading of that bill.
H86, an act relating to Vermont's adoption of the Audiology and Speech Language Pathology Interstate Compact.
Now you've heard the first reading of the bill, and it is referred to the Committee on Health and Welfare. H465, introduced by the Committee on Government Operations. Please listen to the first reading of that bill.
H465, an act relating to Regional Emergency Management Committee's meeting quorum requirements.
Now the bill has been read the first time and is referred to the Committee on Government Operations. And finally, H466, introduced by the House Committee on Government Operations and Military Affairs. Please listen to the first reading of that bill.
H466, an act relating to technical corrections for the 2023 legislative session.
Now the bill has been read the first time and is referred to the Committee on Government Operations. We have on the calendar S60 for action. That brings us to the orders of the day. And we have on the calendar for action S60, introduced on February 7th, was referred to the Committee on Finance, which reports that it has considered the bill and recommends that the bill be amended as appear on page 476 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of the bill.
S60, an act relating to local option taxes.
I'd like to recognize the senator from Franklin, Senator Brock, for the report of the Committee on Finance.
Thank you, Mr. President. This is a bill that relates to local option taxes, and all of you who've been here for any period of time are familiar with local option taxes, because in every session we have 1 or 2 or 3 of these related to charter amendments that we have to discuss. You'll be thankful that if this bill passes, we won't have to do that anymore. And so there's a net savings of legislative time, if nothing else. We have in statute right now a provision in which municipalities can vote to add a local option tax of 1% on rooms and meals taxes and taxes of alcohol beverages collected in their municipality. And what this bill does in a nutshell is it eliminates the legislature from the process and allows municipalities to do so after their legislatures consider their town, their boards of select persons or their city councils to approve it, and then the voters of the community also by a ballot also approve it. Beyond that, this is a very simple bill from that standpoint. The underlying bill was amended by the Committee on Finance to leave in place the ability to make the change. And part of making the change also includes the ability of the Department of Taxes to provide certain information to the municipality about the taxes collected, the type of taxes and amounts, but adds a confidentiality requirement to ensure that that information is not spread, because sometimes there are a limited number of establishments of a certain kind in municipality, and we don't want to identify tax information that should be private and confidential. That adds that requirement to this bill. If you take a look at, there are 2 things. One is the underlying bill, and then there's the amendment that the Committee of Finance took up. The first is it eliminated Section 2 of the original bill, which was simply a closing section, and added to it Section 2 and 3 of the bill that dealt specifically with a single town, the town of South Hero. In the underlying bill in Section 1, if you go through the bill, it authorized local option taxes, as I mentioned, to be allowed under certain circumstances. It indicates that these taxes could include a 1% sales tax, a 1% meals and alcoholic beverages tax, and a 1% rooms tax. And then it added the provision of the confidentiality of tax return information that might be disclosed to the leaders of a municipality to help them manage their tax situation. It then adds, as an amendment, 2 sections of the bill. The first is one that eliminates the requirement for a charter approval before a local option tax can be proposed for the city or the town of South Hero. And then in Section 3, it allows a local option tax for South Hero. This is typically what we've done in the past, but in South Hero, it's a little unusual because they did it in reverse. In terms of what they passed was not in the order that's required for the legislature. It's a simple administrative error. We fixed that here and allowed South Hero to do the 1% tax that they request. For this particular bill, we heard from, among others, Tucker Anderson, Legislative Counsel. We heard from Senator Thomas Chittenden, who was a sponsor of the bill. We heard from the Director of Public Policy and Advocacy of the Vermont League of Cities and Towns. We heard from Senator Keisha Ram, sponsor, along with Senator Chittenden. And then we heard from Rebecca Samaroff, the Deputy Commissioner of the Department of Taxes. And the vote of the Finance Committee was 7-0-0, and we ask for your support. Thank you, Mr. President.
Thank you, Senator from Franklin. The question is, shall the Senate amend the bill as recommended by the Committee on Finance? Chair recognizes Senator from Addison.
Thank you, Mr. President. I am surprised to see this amendment by the Finance Committee. There was a bill in the Government Operations Committee that was presented to us as a charter change, but related to the town of South Hero. However, the town did not follow the required legal procedures. They did not do a vote of a charter change for the town of South Hero. They did it simply as a ballot initiative, which is not permitted under current law. So the voters of South Hero were not presented with the proper question, and the local municipality did not follow the proper procedures. So we chose not to act on that bill, and we're in the process of writing a letter to the town to describe the procedures that they needed to follow in order to do it. So this is really just a backdoor way of skirting around local municipal law and the charter change process in current law, and also the jurisdiction of the Government Operations Committee. So I'm not sure what the procedure is at this point, but I really ask that we not do this amendment at this time.
Senator, are you asking to interrogate either the reporter or the chair of finance, or are you making a motion?
I guess I would like to make a motion that we wait on this bill, or I'm not sure of the proper motion. I'm sorry, Mr. President.
I'd like to declare a brief recess.
A recess, thank you.
Want to do both things at the same time.
That would be my recommendation.
The Senate will come back to order. Senator from Madison has the floor.
Thank you, Mr. President. I move that we delay action on this bill for 7 days until a date certain of March 29th, 2023.
You've heard the motion from the senator from Madison to delay action on S60 for a week to a date certain of March 29th. Are you ready for that question? Senator from Bennington.
Mr. President, this issue has been with us for as long as Act 60 was involved. I can remember sponsoring this bill numerous times. Finally, I gave up, and I'm happy that the senators from Chittenden, and I don't know the South and the North and the East and the West, but the two senators from Chittenden who sponsored the bill. The problem was always the other body, and I would hate to see a bill of this importance get through the Senate and not be taken up because of crossover deadlines. Can we be assured that holding up for a week on this bill would not impact the crossover deadline?
I believe, Senator, that the crossover deadlines refer to exiting committee, not exiting the chamber. So it has met crossover.
Thank you, Mr. President.
Again, you've heard the motion from the senator from Addison. Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. No. The ayes appear to have it. The ayes do have it, and you have delayed action on S60 to a date certain of March 29th. We have on the calendar for action a series of third readings, the first of which is S35. Please listen to the third reading. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
S35, an act relating to the Town of Hartford's Tax Increment Financing District.
You've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have passed S35. We have S36, an act relating to permitting an arrest without a warrant for assaults and threats against healthcare workers and disorderly conduct at healthcare facilities. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
S36, an act relating to permitting an arrest without a warrant for assaults and threats against healthcare workers and disorderly conduct at healthcare facilities.
The question now is, shall the bill pass? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. Nay. The ayes appear to have it. The ayes do have it, and you have passed S36. We have S99, an act relating to miscellaneous changes to laws related to vehicles. Are there any amendments before third reading? Senator from...
Mr. President, we'd ask to pass over this bill for today.
My mistake. We will pass over S99 and come back to it at our next session. We have on the calendar for action S47. It was read the first time and introduced into the Committee on Health and Welfare. And please listen to the second reading of the bill.
S47, an act relating to the transport of individuals requiring psychiatric care.
The Committee on Health and Welfare has reviewed the bill and reported that it ought to pass. It is now listed on page 478 of your calendar. I'd like to recognize the senator from Chittenden Southeast for the report of the Committee on Health and Welfare.
Thank you, Mr. President. May I speak to the strike all amendment proposal?
You may.
Thank you. So this bill is a bill that is correcting some language that's been in place and in statute since 1967. And it's about mental health folks who are in difficulty in a crisis situation, and really looking at how we can improve language based on the current system of mental health care in our state. So in 1967, we had transport to the Vermont State Hospital in Waterbury, and we had transport to our inpatient facilities. Today, we have 16 designated crisis centers across the state that are operated by our designated agencies, and we have community services. We have embedded mental health counselors and social workers with our public safety folks. So the system has changed dramatically. And this bill clarifies language to be consistent with current practice about who can transport, who can take a mental health patient into custody for involuntary assessment or treatment. So as you go through and as we look at the bill, you'll see the word warrant, and the warrant that's referred to here is not a warrant for arrest. It is not a warrant for arrest. Rather, it's more of a certificate for emergency involuntary exam. So an examination of the individual to determine whether or not they need to have further help, mental health care support, and it's exams for someone who appears in the community to be in danger of harming him or herself or others. So as you look at the bill that is on page 478, and I'll go through very briefly the sections to clarify the language that's in the bill. First of all, there is some language correction to the statute. So licensed is put before physician throughout the bill, and then there's gender neutral language throughout the bill. Section 1 of the bill amends that the language in underlying statute that only a law enforcement officer, not a mental health professional, can take a person into temporary custody. So it's either when the mental health care professional or the public safety officer determines that a person is in need of treatment, and a licensed physician may not be available, so the patient could be taken into temporary custody, taken to a safe place until a licensed physician can certify that the individual should undergo an exam. The other clarification in the bill is that a law enforcement officer or a mental health professional, only if it's clinically appropriate, a mental health professional may transport a person to a hospital or other safe place. A law enforcement officer can transport the mental health patient or presumed mental health patient. While the person is in custody, the mental health professional or the law enforcement officer must apply to the court for the warrant, or for, as I was saying before, the warrant in this case is to determine that an emergency exam then would be needed, and then for treatment. And the court can only order a law enforcement officer. This is another correction in the underlying statute. The court can only order the law enforcement officer to transport a patient to a hospital for evaluation by a licensed physician. But as I said before, the mental health professional, if it's clinically appropriate, can transport the mental health patient. Section 2 of the bill is on page 479, and the clarification here is about transport. So a person who is believed to be in need of treatment can be transported to an emergency department or to an inpatient setting, but it also requires that this be done safely, and that the first option would be for the use of soft restraints, and that is actually the part of the importance of this bill, is that when people are under such duress in a mental health crisis, it's important not to add stigma or harm to them. And so the soft restraints become important in the transport, whether it's in temporary custody or whether it is for the exam. The Senate Health and Welfare voted 5-0 on the bill, and we heard from a number of folks in our committee, and these were many of the people that we heard from represent a group of people who got together in the off session. Vermont Care Partners called meetings together and included members of the Department of Mental Health and others, and I won't list them all, but we did hear from many of the people who brought the language to us and helped to clarify that, improve the statute so it does represent what's happening in the field today. Very briefly, we heard from Legislative Counsel, the Commissioner of Department of Mental Health, the Commissioner of Department of Public Safety, the Director of Mental Health Programs for the Department of Public Safety, Vermont Care Partners, and then the Director of Mental Health Services, Vermont Care Partners, the Lamoille Sheriff, County Sheriff, the Vermont Police Association, the coordinator for Team 2, and Team 2, by the way, is the training arm for public safety with regard to mental health. We heard from the Director of Mental Health Law Project, the program of the Clara Martin Center, and First Call, the Howard Center in Chittenden County. Mr. President, that is the report. Thank you very much.
Thank you, Senator from Chittenden Southeast. The question now is, shall the Senate amend the bill as recommended by the Committee on Health and Welfare? Are you ready for that question? Senator from Chittenden Central.
Thank you, Mr. President. May I inquire of the presenter of the amendment?
The reporter will be interrogated.
Thank you, Mr. President. Did you hear from anyone from the mental health advocacy community on this bill?
Thank you very much for that question, Madam President. I'm not sure how to answer that, because I think that many of the people that we heard from are in that advocacy group. So I would include within that the Mental Health Law Project, or the Clara Martin Center, or Vermont Care Partners, or the Howard Center. If you're asking, did we hear from an individual who has a mental health, had a mental health illness, we did not. We were asked at the last day of testimony by Mad Freedom if they could testify, and we invited them to testify, but they were unavailable.
Thank you.
Again, the question is, shall the bill be amended as recommended by the Committee on Health and Welfare? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have amended the bill as recommended by the Committee on Health and Welfare. The question now is, shall the bill be read the third time? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have ordered third reading of S47. We have S73. It was referred to the Committee on Economic Development and Housing Affairs, which reports that it has considered the bill and recommends that the bill be amended as appears at page 480 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of the bill.
S73, an act relating to workers' compensation coverage for firefighters with cancer.
Now you've heard the second reading of the bill. I'd like to recognize the senator from Windsor, Senator Clarkson, for a report of the Committee of Economic Development.
Thank you, Mr. President. I will be referring to our strike all amendment on page 480 of today's calendar. And may I speak to that strike all, Mr. President?
You may.
Thank you. Vermont has about 5,000 firefighters. About 270 of them are career firefighters, and the rest, just over 4,500, are volunteers. As you might suspect, firefighters have a substantial increase in the risk of developing cancer compared to the general population. The contents of the smoke and burning materials they breathe and the chemicals they are exposed to in foam and in their equipment, we're discovering, means that they are 10% more susceptible to getting cancer than non-firefighters and have a 14% greater chance of dying from cancer than the general public. Firefighters are exposed to over 200 known chemicals in smoke, and cancer is the #1 killer of firefighters. In 2007, Vermont law created the presumption that any firefighter who contracted cancer and had either A, been screened before becoming a firefighter, or B, was screened between July of 2007 and July of 2009, would be eligible for the presumption that the cancer was caused by their work as firefighters. In order to be entitled to this presumption, the firefighter would also have to meet these criteria. 1, be engaged in firefighting or other hazardous duties in Vermont for at least 5 years, contract the cancer while serving as a firefighter or within 10 years after serving as a firefighter, be under 65 years of age, and 4, not have used tobacco products within 10 years of the cancer diagnosis. So the bill before you addresses 2 problems with the law in its current form. First, most firefighters are not getting the benefit of this law because they didn't know they had to be screened before they became a firefighter. This bill allows people to have a screening after they've become a firefighter. The language is while serving as a firefighter, and will be covered by workers' compensation going forward if they have a clean screening and if they qualify with the 4 requirements I just read to you. The bill recommends that going forward, fire departments maintain incident reports for at least 10 years and offer or provide cancer screenings for all firefighters. Early detection has proven to be the best route to identifying and treating cancer in our with our firefighters. And the second problem we solve is that because now we have a significant number of female firefighters, we needed to update the list of cancers to include thyroid, breast, and reproductive system cancers. Nationally, female firefighters are being diagnosed with elevated rates of breast, cervical, bladder, ovarian, and thyroid cancers. The last section of the bill directs the Division of Fire Safety to report back to the General Assembly on the projected costs for the state and to fire departments to fund annual or biannual cancer screenings for all career and volunteer firefighters in Vermont, the cost to screen all enrollees in the Fire Academy Firefighter 1 certification program, opportunities for reducing the cost of screenings for fire departments, and to report on the projected cost to the state and to fire departments of replacing personal protective equipment for all career and volunteer firefighters. The report may also include recommendations for legislative action to further facilitate early identification of cancer in firefighters, the acquisition of personal protective equipment by fire departments, and the elimination of PFAS and other carcinogens in firefighting equipment. We heard from our wonderful legislative counsel, who I hope is here in the room, our director of the Division of Fire Safety within the Department of Public Safety, our president of the Professional Firefighters in Vermont, the chair of Vermont State Firefighters Association, the volunteer, one of the volunteer groups, the director of grassroots operation, Americans for Prosperity, one of our former colleagues, and the captain of the New Haven Fire Department. And our vote in Senate Economic Development was 5-0, and we ask for your support, not only for this bill, but for our firefighters, to whom we owe such a debt. Thank you.
Thank you, Senator from Windsor. The question is, shall the Senate amend the bill as recommended by the Committee on Economic Development? Senator from Caledonia.
May I inquire the report of the bill?
Reporter of the bill will be interrogated.
Thank you, Mr. President. Just a inquiry. Would you anticipate these annual screenings to be compulsory? I could imagine some people may not want a colonoscopy, or I don't know the extent of the screenings. And so I was just wondering if the report would talk about whether in order to comply with this, would there be requirements around screening and what procedures might be involved? Thank you, Mr. President.
Thank you, Mr. President. At the moment, they're permissive, and I think that we are going to rely on the report to look at what the cost is and to make a recommendation to us as to how we would handle that cost going forward and that requirement. At the moment, it's permissive. However, if there is no screening, there is no presumption of being covered. So you're sort of caught between a rock and a hard place. While we may not want to require screenings, unless we have screenings, you can't know and you won't be covered.
Thank you, Mr. President. I guess that it shows kind of the circular nature involved here. So thank you very much.
Yeah.
Again, the question is, shall the Senate amend the bill as recommended by the Committee on Economic Development? Senator from Bennington.
Thank you, Mr. President. May I inquire of the presenter as well?
You may.
Mr. President, so I'm sorry if I missed this, what does the screening involve itself, given the complexities of the cancers? What would we be requiring? Is it a simple blood test, or is it more complicated?
I believe there are a number of screenings, Mr. President, and it depends. I believe there are a variety of screenings. And I can certainly get back to you by third reading as to what they are, but there are a variety. Some are more involved than others.
So thank you, Mr. President. So it's possible somebody may feel as though a blood test is adequate enough, submit that, and that would be adequate? Is that possible, given that the variety out there?
I think that's what we're relying on the report to do. I think that we will be hearing of the variety of tests, what are more affordable than others, what we may be asking, whether it would be, so I think that's what will be covered in the report. That's my understanding.
So the bill, this part will not go into effect until the report comes back and clarifies what the cancer screening would be?
No, this bill takes effect in July and will cover these additional cancers so that we are sure that we're covering cancers that our female firefighters may be subject to. And it does make it immediate as of July. It makes it permissive for fire departments at the moment to offer screenings, and it also enables that firefighters who are currently firefighters may get a screening now and encouraged to be screened now.
Thank you, Mr. President. So I would appreciate just knowing what that screening would look like now, and then possibly, what might come back from the report, just some, a guess, if you would, a little bit from what the committee's taken testimony on, to just kind of understand whether, the thoroughness, if you will, of the testing. Thank you, Mr. President.
Thank you. We'll have that tomorrow.
Thank you.
Thank you.
The question is, shall the bill be amended as recommended by the Committee on Economic Development? Senator from Bennington.
President, may I inquire the reporter of the bill?
You may.
President, in reading over this bill and the cancers that are cited, I'm a little worried about leaving untouched the issues of firefighter with use of tobacco in the last 10 years. what we've learned from the Bennington experience with Bennington, North Bennington experience, the cancers that have been identified due to PFOA contamination have nothing to do with lung cancer. There are other forms of cancer. So you would be, I think, remiss, particularly you're eliminating a certain group of people who the cancer that they get is not a result of the smoking, but other things. I mean, I understand what they were getting at when they wrote this bill years ago, but I would hope that the report or something could reflect looking at that. All the cancers you pointed to because of the addition of female firefighters, probably not due to smoking, but other factors. And knowing that PFOA was involved in the foam that was used for training firefighters, I think is an important factor. So I think it's remiss if we're redoing this law to not look at that factor. Thank you, Mr. President. I don't know if there's any comment. I guess I was more of a comment than a question, but I wonder if you could comment on that.
Thank you, Mr. President. I would be happy to speak with the senator about a possible amendment that we could add to or have a huddle with our legislative council on how we could address that. And I'm happy to explore that.
Thank you. I don't take either of those comments as motions. I did hear a suggestion of collaborative activity, which sounds positive. Thank you,
Well
Senator
put,
from
Mr.
Bennington.
President.
Sorry?
Well put, Mr.
Thank you. The question is, shall the bill be the senator from Bennington?
Thank you. Just one follow-up question for the reporter, if I may, Mr. President. Did
You may.
Dr. Levine, the Commissioner of Health, weigh in on this bill?
No, he did not.
Okay. Okay. Thank you. Thank you, Mr. President.
And I'll restate the question. Shall the bill be amended as recommended by the Committee on Economic Development? The senator from Orange.
May I interrogate the reporter of the bill?
You may.
Mr. President, the line between comments and questions. It's always difficult. Would we be having this discussion if we had a single-payer healthcare system?
Is that a rhetorical question, Senator? Or do you require an answer? Senator from Orange.
Is it rhetorical? I'm not sure. I don't know. But I appreciate that if we had that in place, I don't know the answer to that.
Mr. President, is it currently the practice to deny firefighters and others, golf course maintainers and healthcare because they may have smoked or had other causes for their cancer than their immediate present employment? Is that a common practice?
I believe that is the case. It's a fairly high bar that has to be met for firefighters to be able to claim this and to be presumed to have gotten the cancer from their work as a firefighter. And I think, yes, they have to be able to show that the risk happened as a result of their work and the exposure.
So we're dealing with a bill that tries to deal with the fact, Mr. President, that there are insurance companies that we and our employers engage to protect us and our health routinely try and find reasons not to provide coverage for cancers that may not have. If I had health insurance on this job, I'd have to claim that I got my cancer from something here. We're running around chasing our tail on this, Mr. President. It's not a question, but a comment.
Thank you.
Thank you.
Thank you, Senator. Senator from Addison.
Thank you, Mr. President. Just a comment to follow up on that exchange just now. I believe, Mr. President, that this bill is about workers' compensation coverage, not health insurance coverage. And so that is why there's a tie to whether or not the cancer would have been the result of their work as a firefighter as opposed to their smoking as an individual. So that it's not about denying an individual health insurance coverage. It's about making the connection between work and the cause of their cancer diagnosis. Thank you, Mr. President.
Senator from Chittenden Southeast.
Thank you, Mr. President. I appreciate the last comment from the senator from Addison. I did want to refocus us and remind us that it is about workers' compensation coverage. The senator from Windsor is doing a wonderful job, but there are a couple of things I wanted to address, and more could possibly be addressed before third reading as well. When it comes to the screening process that's articulated in the bill, some might consider it more of a pre-screening process. What we heard is it's about a $300 diagnostic blood test that helps flag abnormalities that the company that provides this blood test service would then encourage you to go explore further with your physician or medical professional that you would normally see. So when we talk about cost, we are talking about more of a low-cost pre-screening option that then encourages the firefighter to go get a much deeper diagnostic test. And there are a lot of companies around the country that offer that pre-screening option. The committee certainly was sympathetic to and heard about both tobacco use and the age that you have to be to take advantage of the workers' compensation access that you would receive. Many of our volunteer firefighters are over the age of 65, and it's very hard to recruit new young people into these roles, as many of you know, having volunteer firefighters, because of the risks that one assumes. But people are constantly celebrating 60 years with their volunteer firefighting company. We do plan to convey further down the process that we might look at these issues either as part of the study or to address with further testimony. Because it's a workers' compensation bill, the same people that supported the bill as it was written would want to come back in and talk about the contingency of their support if we took on those two issues, because it opens up a lot of new liability. And so we, for now, to maintain our crossover timeline, let those issues go and plan to convey them further in the process. Finally, just because it is a workers' compensation bill, the majority of our testimony from the state was from the Department of Labor. We certainly can communicate to the other chamber or further in the process that they may want to hear from other agencies or departments, but many of those agencies or departments declined to be heard because this is a matter for the Department of Labor. Thank you, Mr. President.
Thank you, Senator. The question again, shall the bill be amended as recommended by the Committee on Economic Development? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have amended the bill as recommended by the Committee on Economic Development. The question now is, shall the bill be read the third time? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have ordered third reading of S73. We have been asked to pass over S89 today, and we'll do so. That brings us to S103, which was referred to the Committee on Economic Development, which reports that it has considered the bill and recommends that the bill be amended as appears on page 495 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of the bill.
S103, an act relating to amending the prohibitions against discrimination.
Now you've heard the second reading of the bill. I'd like to recognize the senator from Windham for the report of the Committee on Economic Development.
Thank you, Mr. President. May I speak to this strike all amendment?
You may.
Wonderful. The bill was in yesterday's calendar on page 467 at the very end, if you want to reference that, and is also in today's calendar. The purpose of the bill, S-103, proposes amendments to the laws prohibiting discrimination in employment and in places of public accommodation. In establishing the baseline for workplace behavior, we are describing the reasonable expectations for how employers and managers will interact with their employees and customers. These expectations are our best explanation to date of a non-hostile work environment. I would argue that a non-hostile and even supportive work environment helps both the employee and the employer. The bill updates the definitions of what is not lawful. The provisions proposed are consistent with case law, which provides more clarity for employers and employees on what constitutes discrimination in Vermont. Please see the chart provided by the Civil Rights Unit of the Office of the Vermont Attorney General, which will help you see instances, all of which show that the proposed amendments are harmonious with case law. Section 1 amends the unlawful employment practice statute. The bill clarifies that discriminatory harassment is unlawful. It expands the equal pay law to apply to race, national origin, and disability. It prohibits settlements of any employment discrimination claims from including a no rehire provision, sometimes called a do not darken my door provision. And those provisions have already been prohibited with sexual harassment settlements since 2018. The proposal provides that harassment and discrimination need not be, quote, severe or pervasive to constitute a violation. And you'll hear those words a few more times. We're specifically departing from a common law case that set the severe or pervasive standard in 1986. That standard has been challenged by more recent harassment cases, and it's no longer necessary to show the evidence of trauma or inability to perform your work duties to prove harassment. We heard testimony that severe or pervasive is sometimes interpreted to be severe and pervasive. And this has led to decisions where a single instance of rape, for example, did not count as harassment, which is obviously not good. Section 2 amends the definitions. They clarify that sexual harassment includes written, auditory, or visual conduct in addition to verbal or physical. Again, this is consistent with interpretations made by the courts. It provides, again, that sexual harassment need not be severe or pervasive to be unlawful. It changes the current definition of harassment, and this one is in response to testimony about situations where an employee's ability to do their job well, even though they were experiencing harassment, was taken as an indication that they were not being harassed. So their ability to perform was actually held against them. So we removed the word substantially and performance to address that issue. So the condition reads, the conduct has the purpose or effect of interfering with an individual's work or creating an intimidating, hostile, or offensive work environment. Section 2 also includes the severe or pervasive language. It's important to note throughout this bill and this law that both existing law and the proposed amendments require that the employee prove that the harassment is related to the protected characteristics and that the employer was aware of the harassment. Section 3 adds the definition of harass to the Public Accommodations Act. The definition was enacted last year for fair housing, but we're now updating it to include places of public accommodation. Places of public accommodation include both governmental entities and private businesses that provide services to the general public. So that would be restaurants, movie theaters, doctor's offices, retail establishments. Harassment is here defined as unwelcome conduct that detracts from, undermines, or interferes with a person's ability to use a place of public accommodation. Again, it need not be severe or pervasive to be unlawful. The definitions will provide guidance to the courts when determining whether harassment is unlawful. And the definitions here do not apply to school harassment lawsuits brought pursuant to the education law. Section 4 deletes language that is no longer necessary because it's included in Section 3. And a likely benefit to employers and proprietors of public accommodations is that the discrimination language will be consistent with case law and therefore should provide clarity to training and management of employees. Finally, just generally, a non-hostile workplace benefits all involved. Many employees in a hostile work environment will choose not to file a suit. It takes a lot of effort and is personally challenging to file suits. Many employees will vote with their feet and leave the establishment. And so especially in a situation where workers need to be valued more than normally because we have a workforce shortage, it's important to update these regulations. So Section 7 is the effective date of July 1st of this year. The list of witnesses, we heard from Carrie Brown, Executive Director of the Vermont Commission on Women. We heard from Richard Cassidy, attorney for Rich Cassidy Law. We heard from Austin Davis, Government Affairs Manager, Lake Champlain Regional Chamber of Commerce. We heard from Damian Leonard, our Legislative Counsel. We heard from Sarah Robinson, Deputy Director of Vermont Network Against Domestic and Sexual Violence. Megan Sullivan, Vice President of Government Affairs, Vermont Chamber of Commerce. Julio Thompson, Director, Civil Rights Unit, Office of the Attorney General. And Bor Yang, Executive Director and Counsel, Vermont Human Rights Commission. Mr. Chairman, your Economic Development Committee passed this bill on a vote of 5-0-0 and asked for the Senate support.
Thank you, Senator from Windham. The question now is, shall the Senate amend the bill as recommended by the Committee on Economic Development? Are you ready for that question? Senator from Caledonia.
Thank you, Mr. President. Just a point of clarification. In the presentation, there was reference to Section 7, and I see that this is a strike-all bill, and in the calendar, it seems like there are only 5 sections. There were 7 in the original bill. So I just wanted to be clear that we are
I will assume, Senator,
strike-all as presented in the calendar.
I will assume you want to interrogate the reporter?
Yes. I don't know if it's a point of order or perhaps I can inquire of the reporter of the bill.
Senator from Windham.
Thank you, Mr. President. I appreciate that. That was an error on my part. I said Section 7 because there was previously an Section 7 and that was in my draft. I should have said Section 5.
Thank you.
I appreciate that.
Appreciate the clarification. I just wanted to make sure that something hadn't been left out.
Very good. The question again is, shall the bill be amended as recommended by the Committee on Economic Development? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have amended the bill as recommended by the Committee on Senate Economic Development. The question now is, shall the bill be read the third time? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed signify by saying nay. The ayes have it, and you have ordered third reading of S-103. We now have S-112. It was referred to the Committee on Finance, which reports it has considered the bill and recommends that the bill be amended as appears on page 501 of your calendar, that when so amended, the bill ought to pass. Please listen to the second reading of the bill.
S-112, an act relating to miscellaneous subjects related to the Public Utility Commission.
Now you've heard the second reading of the bill. I'd like to recognize the senator from Addison, Senator Bray, for the report of the Committee on Finance.
President, as the amendment offer, may I speak to the underlying bill as well as the amendment?
You may.
As we make only one brief proposed amendment to the underlying bill, I'll be walking through the bill itself. S-112 is a housekeeping bill offered on behalf of the Public Utility Commission, which brings us a similar bill to it each year. Generally, in order to make modernizations to current statute, in order to evolve with changing times. So, going to section 1, this relates to how certificates of public good are awarded, and the changes that take place. You'll see the first one is on page 2 of the bill, where it refers to public hearings shall be held in person or remotely accessible, or both. A number of these changes reflect post-COVID practices where the utility of having remote as well as in-person hearings was appreciated by all parties. On the next page, page 3, lines 13 through 15, you'll see an ability to waive current timelines, which require the response of the Public Utility Commission within 120 days. There are situations in which complex proceedings are underway, and both the applicants as well as the PUC agree that additional time would be beneficial to all parties. This provides an opportunity to waive that 120-day timeline requirement. At the bottom of page 3, that begins subsection U, and relating to energy storage facilities. I'll be coming back to that when I speak to the amendment being offered by the committee, but we will be proposing to strike that section, and I'll be happy to explain why when we double back. Section 2 goes on to revision of definitions related to corporations. They are simply revised on the bottom of page 4 and through the top of page 5 to align statute and current practice. Subsection 3, which follows, relates to hearings. Again, it's modernization of the current law related to providing opportunities to have hearings held both in person and making them remotely accessible. Section 4 begins on the bottom of page 5. In a similar way, we add on page 6 language around remotely accessible hearings. And then in terms of notice provisions, they are revised to include a traditional announcement in a paper of public record or general circulation, as well as to be published on the PUC's website. Moving on to section 5, we get into suspension proceedings. There is a requirement that proceedings happen within a 7-month period. Once again, because proceedings can be more complex, both parties can waive the requirement to timely, as in 7-month process, and ask for more time in order to get to a better resolution. On page 8, we get to the rulemaking authority of the Public Utility Commission, and then there are revisions they carry from this section on through section 9. In section 6, the PUC addresses the fact that in order to make their proceedings more accessible to public at large, they stop incorporating the rules of judicial procedure by reference. Because unless you are a lawyer as opposed to a regular citizen who was interested in proceedings, you might well not be familiar with the rules of judicial procedure. The PUC then revised their rules to spell out the procedure in their own rules. in order to make it sort of one-stop shopping for figuring out how to be engaged in a proceeding related to pleadings, practices, evidence, procedure, and forms for commission proceedings. The downside of doing that was when they used to incorporate and their rules merely referred to the rules of judicial procedure. That meant without any work on their part, they would stay current. As the rules of judicial procedure were revised, they were always pointing at the most current rules. Now that they're carrying that burden themselves, they need an ability to revise the rules, and this specifies how they can do that. The short of it is that they are allowed to make such revisions, and then they bring them to the Legislative Committee on Judicial Review rules for review. On the top of page 9, we make explicit that the General Assembly doesn't yield any current authority in subsection 5. Subsection 7 just revises definitions. For instance, the commission refers to the Public Utility Commission, and then refers back to the rules we've just been talking about with a cross-reference to Commission Rule 2.1000. Section 8, again, carries forward a revised language referring to the newly defined phrase commission. Section 9 carries on the same revision of language. Section 10 gets the rules of evidence, and on line 12, we modernized the language. There was, although we cleaned up statute years ago to address gender bias in statute, somehow this, the word men appearing in line 12 of the underlying bill was missed, and so the PUC would like to revise that to persons. Section 11 is the effective date, and I just wanted to double back to subsection U, which begins on page 12. The Finance Committee is recommending striking that section, and the reason was that as we looked into definitions and practices related to energy storage facilities, which is an area of evolving technology and law, we found that there was enough uncertainty or different reasons to slow down and have an opportunity for more discussion before making this change. Therefore, the Finance Committee recommended removing that until those discussions have taken place and they can be brought forward in a future bill. The committee vote was 7-0-0. We asked for your support. We had 9 witnesses in. The bill sponsor, the Vice President of Development from Encore Renewable Energy, the Director of Policy and Planning from the Agency of Natural Resources, our Legislative Counsel, Ms. Czakowski, the General Counsel of the PUC, the General Counsel of the Agency of Natural Resources, the General Manager of the Vermont Public Power Supply Authority, a regulatory specialist from Burlington Electric Department, and a representative on behalf of Green Mountain Power.
Thank you, Senator from Madison. Question is, shall the bill be amended as recommended by the Committee on Finance? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have amended the bill as proposed by the Committee on Finance. The next question is, shall the bill be read the third time? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have ordered third reading of S 112. That completes the orders of the day. I would look to the senator from Windsor for a motion.
Thank you. Pending announcements, I would move that the Senate stand in adjournment until 11 a.m. on Thursday, March 23rd.
The senator from Windsor has moved that the Senate, pending announcements, stand in adjournment until 1 a.m. March 23rd. I'm sorry, 11 a.m. on March 23rd. Senator from Addison.
Thank you, Mr. President. The Senate Government Operations Committee will meet at 1:15 this afternoon. Thank you.
Senator from Essex.
Mr. President, I just want to take a moment, if I could, please. And I just, last week, the chair of Natural Resources, the senior senator of Addison, did a nice thing that I believe was a very nice thing, and saw a problem or something that he thought that pertained to the Institutions Committee, and reached out and asked if he could meet, and not only that, but supplied the people who would best know about the subject as it wasn't at hand. And we met a few days later. And I bring that up, Mr. President, because as your role as pro tem, I've been very thankful for what you've done as far as mentoring the 10 new senators that come in. And I took that as a moment as well in the committee to show how proper communications could happen between two committees. I think it went very, very, very well. I've told my committees several times as they thanked me for what I'm supposed to be doing as far as being fair with them and giving them time. I've said to them a few different times that my role as chair, I see it not only as to run a good committee and be fair to all, but also at some point in time to ready them for when they are in that position as well. And I was thankful just to have that moment with the senior senator of Addison being fair with us, bringing in his concerns of the bill that he had in his possession and bringing it in and making it not a concern of ours. And thank you. And Senate institutions will meet at 1 o'clock today.
Thank you, Senator. Senator from Bennington.
Thank you, Mr. President, and thank you, Senator from Essex. I've been mentoring the senior senator for decades now. And finally, I have a moment of success. So. Mr. President, Senate Education will meet at 1:30.
Are there further announcements? Senator from Washington.
Thank you, Mr. President. Senate Finance will meet at 1:15. We got 2 more bills yesterday.
Senator from Caledonia.
Senate Appropriations will meet at 1 promptly. Thank you.
Senator from Chittenden Southeast.
Mr. President, Senate Economic Development will meet at 8 a.m. tomorrow morning with apologies.
Senator from Windsor.
No offense taken, there's no apology needed. 8 a.m. it is. Thank you, Mr. President. Tonight's Farmers Night, we are going to have a special treat. Brian Blanchette, who is known to many of you, and the Black Bears are going to perform. Brian is an Abenaki singer and songwriter, and is going to be performing contemporary and traditional Abenaki songs, and he's going to be doing some dance demonstrations. So anyone, I would encourage all of you to come, 7:30 tonight in the House chamber. I also want to let you know that Cabaret is now scheduled for April 13th. So Senate needs to start prepping now. Thank you, Mr. President.
Any additional announcements? Senator from Addison.
Thanks, Mr. President. Senate Natural Resources and Energy will meet at 8:30 tomorrow morning.
Senator from Chittenden Southeast.
Thank you, Mr. President. Senate Health and Welfare will meet at 9 rather than 8:30 as previously scheduled tomorrow morning.
Any further announcements? Seeing none, the senator from Windsor has moved that the Senate stand in adjournment until Thursday, March 23rd at 11 a.m. Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and we have adjourned until Thursday, March 23rd at 11 a.m.